Hello everyone, my name is Vinay Ahuja and welcome to all of you. Indonesia is perhaps the most convincing investment destination across ASEAN. 290 million people, good 5% growth rate, and a convincing story to attract global capital. But here is the game. In M&A, potential of a country is not on what its growth is, but can you execute the deals into that country? And Indonesia is one of them which definitely test these execution capacities. It will be fair to say that if in ASEAN or generally in Asia, if there was one destination which was talked about a lot and least understood, then Indonesia would be up the charts. And it becomes more complex when the legal and the tax advisors come into the picture. So in today's episode, we are talking about running away from the headlines, unpacking the intricacies of actually how the deals are done in Indonesia and whether they can be executed the way they are looked upon, or what are the challenges generally faced by the investors. So to discuss that, we have an expert panel covering both legal and tax. So to join, I have Afriyan. Afriyan is a partner with Nusantara DFDL Partnership. He sits with significant experience on the cross-border M&A, disputes, and infrastructure. Joining Afriyan, we have got Sri. Sri has got a sharp lens for regulatory, structuring, and M&A execution capacities. I often say if Afriyan is the person who will help you navigate the legal landscape, Sri will ensure that you don't overtrip it. To balance the legal, we have tax partners from PBTaxand, one of the leading tax firm in Indonesia. Again, in any country said, your deal can be legally workable, but it's only successful if it's tax efficient. So here, the tax partners come into the picture. So we have Aristo, again, a senior corporate tax partner, has done a lot of work across Indonesia and advising a large number of clients looking to invest and do their tax structure in Indonesia. Joining him is Alice, a very seasoned tax partner and definitely working on a lot of issues that clients face after deal signing. So hopefully we'll discuss some of them today. So that's kind of the panel we have, and let's get straight into it. As a foreigner looking from a plane 30,000 feet, 35,000 feet, Indonesia might look very straightforward. But the moment you land, or they say when you are executing the deal, you often face challenges. So if I can start from a legal side, what attracts Indonesia as a destination, and what are the challenges that you see from a legal side investors see in Indonesia? Sri.
Okay. Actually, it's a question that often comes up to us as a lawyer. But in this particular chance, I think it's best if we talk about the positive side first, because it's always the easiest, and because this is the first question. So yeah, I think we should start from the good point. I think you already touch a bit of why Indonesia is very attractive. I think let the number speaks for itself, right? I mean, we have huge population, big population, over I think almost 290 million people. So we have big market. I think we're the biggest market in Southeast Asia. We have very good growth in middle class, and we have huge population, young population. And I think the government itself is very supporting of foreign investment, especially since the issuance of Omnibus law, where we see many upgrades in terms of relaxation or flexibility when it comes to foreign investment. Now, when it comes to the challenging part, we might need 31 hours if you want to discuss this thoroughly, because of the limited time. I think I'm going to only touch a couple of important points. If I should mention, I think the first significant point in Indonesia is that foreign ownership is still limited in terms of not all sectors are open for foreign ownership. And I think it will also be affecting the timeline. It's unlike in Singapore, basically once the deal's done, you can start. Here, no, you need to deal with several government authorities. You need to apply some approvals, you need to submit some notifications. Not to mention, when it comes to specific sector business activities, you probably need to deal with additional requirements, and you need to deal with additional specific sector authority governments. Having said that, doing M&A deals in Indonesia, I think the clients or the investors, what they need to do is they need to manage their expectations when it comes to the timeline. And they really need to think from the get-go, from the start of the regulatory requirements, and it needs to be part of their deal preparation. Second point, I think this has come up in a real case scenario, especially when the client is coming from a Western country where the scheme or the theme of double boards, like two boards, are quite unique for them. They always come up with a question, why I need two boards? Why can't I just have one board? I mean, this is how I do business back in my original country. We're like, no, we need two boards. We need board of directors, we need board of commissioners to totally handle different functions. Day-to-day basis, you need board of directors. Commissioners they're doing basically supervisory oversight functions. And because of these two distinct separation, we need to emphasize to the investors, just because you own shares does not mean you control the company. So you need to understand this framework. You need to understand the interest, where you need to place your interest and where you need to regulate them. And having said that, I think it's very important for them to engage the right partner as a legal consultant and as a tax advisors. If I can wrap this up in a simple sentence, I think Indonesia is very attractive because of the, vast opportunities, endless opportunities. But it can be a bit a struggle when it comes to the rules. But once you understand the rules, it'll be easier.
Interesting. So it's not only about the investment, it's also about power. It's like Game of Thrones, where power also plays an important role. Bring in the tax lens, again, it's not only about whether you are investing good, it's also about investing efficiently and where the tax picture comes into the scene. So Aristo, if I had to put the same question to you in terms of tax, what attracts Indonesia and what challenges you see from a tax lens for investors in Indonesia?
Okay, so Indonesia is trying to be attractive for investors. So the government try to offer many tax incentives nowadays. So we have tax incentive for free trade zones, like if you have business in Sabang and then Batam, you can enjoy tax benefits there. Super tax deduction and special economic zones. And lastly, we have tax facilities for the business owner or investor that want to have business in our new capital, Ibu Kota Nusantara. So for investors that want to invest in Indonesia, I think they need to take a look first whether their business can use or utilize that tax incentives. That's the attractive from Indonesia point of view. And the challenge is, in Indonesia, we have many type of taxes. So if I'm not mistaken, we have around 11 type of tax here. So we can divide into 3 type of tax. Now, number 1 is central tax, that the corporate income tax, withholding tax, value-added tax. And then we have a regional tax that will be paid to the regional government. And so the investor must know what kind of tax obligation they need to fulfill when they come to Indonesia and doing business here.
Understood. So, if I summarize, the summary would be before an investor decides to venture into Indonesia, doing a market entry analysis or engaging consultants at the stage of market entry would be helpful. That will determine what challenges will be applicable to them and what resolutions they can have for those challenges. So, let's say going a little more practical. For a lot of investors, it's always not about what they know or they don't know. The question comes what they miss. So, whenever an investor is coming into any new market, the first thing they will do is a legal and a tax due diligence. So, Afriyan, I'll ask you to share your thoughts on it. So, from a legal standpoint, what are the core critical due diligence issues you see from a foreign investor looking at Indonesia market?
Okay, thank you, Vinay. So from the perspective or legal perspective, what I can see is the license and permits. I think that is number one, the critical one in Indonesia. A lot of license, also permits from the states, from the regional government. So this is kind of important. Many of regulations also from the states and also on the regional regulations. And as a consultant, we usually advise based on the specific locations. So, as mentioned by Aristo previously, it's also different if you are in the special economic zone or in the bonded zone, or you are in the area of the industry, or even like in the city. So that is number one, license and permits. That's for what I can see. The second thing is about foreign limitation. Like Sri already mentioned also, this is quite important in Indonesia. Some of the activity still have some foreign limitation for construction kind of thing, or for specific like energy or mining. There is divestment. There is also a domestic market obligation also for energy. This is kind of important that for the investor to look after it. Probably that's basically what you need to look.
Fair enough. Again, this is more looking from licenses, regulatory approvals, zoning, land related. But when it comes to tax, we often see that the disclosure elements are discovered after the deal is signed. And a lot of issues come out about a potential tax was not paid or disclosed, or a financial transaction was not disclosed, and they come up later, which possibly are not discovered at the time of due diligence. So, Alice, you want to take up again from a due diligence perspective? Is there something what investors overlook on a tax side, and what they should be careful of? Aristo, again, if you want to take this. Sorry.
Okay, so when the investor want to acquire a company, so usually they have conduct a thorough tax due diligence,
Right.
because they want to know about the historic tax compliance that has been done by the company or the target company. So the critical point is when they do the tax consultant conduct a tax due diligence, so the tax consultant must able to see whether there is a potential tax exposure that may arise when post the acquisition. Because when we are doing tax due diligence, we are going to do a reconciliation, we are going to see the cash flow analysis, something like that. We are going to see for the inventory flow, something like that, Vinay. So, and then sometimes we also find that there is a gray area in a regulation. Sometimes this become a big problem because maybe it is an industry issue that not only this company face for the tax, but so if we see this, sometimes we inform the potential investor, and maybe one of the solution is we can ask for advance ruling from the tax office. So that may avoid the tax dispute in the future.
Understood. So honestly, from a diligence perspective, what I can gather is due diligence still forms a very core part of a transaction or a M&A transaction happening in Indonesia. Our suggestion always is that one should do it at that time of signing the term sheet. It should not be a post-deal activity. So that's kind of the recommendation which comes through, and there are various components which come in depending on the size, sector, and area of the transaction. Now, Indonesia is part of ASEAN, and generally, Indonesia is always this story which comes along with the expansion plan in ASEAN. Again, as DFDL, we are present in 9 countries of the ASEAN, and we do a lot of these kinds of transactions where it's Singapore element, Vietnam element, Indonesia. So there are multi-jurisdictional mandates which come through. So I want to understand your experience of how does a deal potentially, if you would have, again, I realize that you may not have a direct experience on doing a Vietnam deal, but when working with your peers or colleagues, what experience you have when comparing a deal in Indonesia M&A sector versus possibly in Singapore or in Vietnam? How do you see the differentiation there? Sri, you have, I know that you have done few multi-jurisdictional mandates in DFDL, so please share your experience there.
That's a very interesting question, Vinay. As you mentioned, me and Afriyan, we both are Indonesian lawyers. But again, DFDL, we have offices across ASEAN, and we are quite privileged to handle cross-border transaction involving multi-jurisdictionals and several countries, especially within the region. If I can put the answers, probably there will be a couple, if not 3, different or distinctions within these countries. My first answer when this kind of a question comes up will be, you basically will choose between speed and simplicity or long-time growth or scale. When it comes to Singapore, everything is fast. Less requirements, correct me if I'm wrong, Vinay, less requirements, few applications, basic is fast-paced. So from legal standpoint and from business standpoint, I believe Singapore is one of the fastest country in order to complete an M&A transactions. But again, one thing we need to highlight, it has significantly smaller scale in terms of the market scale compared to Indonesia and Vietnam. When it comes to Vietnam, of course, it's not as fast as Singapore, but it has its own complications. Especially if I can mention one particular example is when it comes to foreign acquisition, they will require what normally known as a government certificate that comes not only from the nation level, but also from the local level. Having said that, what I noticed when it comes to Vietnam is that they are very local practice-centric. So the local practice still plays a huge part when it comes to transaction. And therefore, how smoothly your transaction will go will highly depend on where the location is. Where your business is. And then for Indonesia, I think when it comes to timeline and speed, as I mentioned in the my previous answer, is that we need to manage the expectation when it comes to timeline, especially when the transaction is involving a specific sector of business activities like mining, infrastructure, that Afriyan has already mentioned that would require additional requirements from additional governmental authorities. I think the other distinct differences that we can see is when it comes to foreign ownership. It's a bit repetitive, but please bear with me because this is the common issues that or common matters that are normally compared by our clients, by the investors. In Singapore, basically it's no limits, all free. You can go. In Vietnam, some limitations. In Indonesia, it's a very sector specific. But again, after the Omnibus law, now it's a bit more flexible. There are more options that are, more option of business activities that are open for foreign investors. And I think the third difference will be, this is a bit significant. This is a dispute resolution. As we all know, Singapore has a SIAC. It's very well known. It's very well accepted internationally. And when it comes to the enforceability of the decision of the awards, I think it's very effective, efficient, and commonly accepted in most countries. Indonesia and Vietnam, of course, we have our own arbitration system. But when it comes to, again, enforceability, historically speaking, it is not as predictable. It is not that easy, and therefore, I think we all, as a consultant, we can see that in cross-border transactions, most of the time, we always use international arbitration, specifically SIAC. So yeah, in summary, if you want to have fast deal, you go to Singapore. But if you want to have a large scale, again, opportunity, you need a bit of patience, and yeah, go with Indonesia.
Yeah, I think I need to add also on that point that I echo what Sri informed about this, but I think the other thing that I would like to add is about you need to have a good partner, a good local partner also in Indonesia. I have experienced that this is a distributor of products. They appoint a local distributor because under the Indonesian regulation, a distributorship is limited. If you are a foreign distributor, you can establish in Indonesia, but you need to appoint a local distributor as your local partner also, or to distribute your products. If you not have a correct or the right partner, that distributor later on can make you can file a claim against you, and then make your life difficult also. That's probably Vinay.
Very rightly said. Again, important counterpart is important, and honestly, last 20 years covering 5 jurisdictions, nowhere is predictable. It's not only about Indonesia, but none of the countries we talk about predictability is sure. But Sri, just a quick 30 seconds on, if an investor is doing a multi-jurisdictional transaction, let's say in a manufacturing industry, you get on a call with the general counsel and he says, estimate-wise, what timeline do you see in closing a transaction for a manufacturing entity? What would be your ballpark timeline?
Oh, for timeline since the preparation until the closing, or
correct, signing the term sheet, due diligence, closing, and possibly. Let's not go into the antitrust approvals, but pre-antitrust, what will be your estimate?
I would say 3 to 6 months.
3 to 6 months.
3 to 6 months. It's a legal due diligence itself, especially when it comes to manufacturing. There will be lots of technical requirements, technical permits, and then we're talking about the term sheets, and then now, especially the Ministry of Law, that they now require a verification processes. So which is recently applied, which require verification and as I've seen in practice, some companies, they're not fully in compliant yet. And for this rectification itself, it can take 1 month for this one step. So yeah, I think 3 months if we optimistic.
Yeah.
But yeah, evaluation timeline 3 to 6 months.
The conclusion
Correct
should
me
be
if you probably
you should have
disagree.
time in your kitty when you are doing a transaction in Indonesia. Tax, again, that's another comparison. What we see very often, again, we don't advise on tax per se on a lot of transactions, but yes, a common questions what a client may ask at times is, I'm a Thai conglomerate, I'm planning to enter Indonesia. Should I enter directly? Should I come via Singapore holdco? So what form of structuring, and maybe Alice, you have done a lot of work on this front. What form of structurings vis-a-vis ASEAN or Singapore you have seen, or what are the general structures which are more beneficial for clients when it comes to regional transactions or multi-jurisdictional transactions?
Okay, thank you, Vinay. I think during the multi-transaction, multi-country, what they ask the first time is how to exit. They want to enter, then how to exit.
Absolutely.
Then, of course, when it comes to exit strategy, then always remind them that there will be the basic rule, there will be 5% withholding tax, the final withholding tax for the foreign investor. So that will be the basic rule. So before we go to the exit strategy, then we need to decide what kind of structure that you want to implement in Indonesia when you want to invest in Indonesia. Of course, when you want to invest in Indonesia, like Sri also mentioned, that they will need to decide. There will be 2 board directors. One is board directors and the other one is board of commissioner. Then they will need to decide whether there will be foreigners in the board of directors and board commissioners. Of course, if they want to control the company, they will need to place one of the foreigners from the origin country to be the board of directors. And for the structure itself, usually they will straight invest to Indonesia. Do you have?
Aristo, you have any experience on similar mandates you want to share?
Yeah, so I agree with Alice that they can come straight to invest in Indonesia, but sometimes they choose to have a hub. Let's say they use a Singapore company as a hub, or maybe a Hong Kong company. So what if they ask both of us, so the investor, we will advise them that first they have to choose the country that have a tax treaty with Indonesia. That's number one. And besides tax treaty, they have to make sure that they can show that they have economic substance. Let's say in Singapore. Singapore now require economic substance.
Correct.
And then when of course the investor, when they invest in Indonesia, what is they expect from the investment? Of course, they two kinds of things that they expect. Number one is maybe capital gain when they sell the shares, right? Or dividend distribution from the investment. So from that 2 things, they need to see whether the tax treaty can or they can enjoy the tax treaty. Yeah. Because that's the most important things. Because if they choose the wrong hub, let's say they use British Virgin Islands, in Indonesia they don't have tax treaty with BVI, so it will be directly when Indonesian company distributes dividend to a BVI company, then it will be directly 20% on the dividends. And when they want to sell the shares, there is a 5% sales tax based on the selling price. So that's a huge tax cost for the investor that they have to consider before they are entering Indonesia.
I know. So again, it boils down to my same initial comment about investors doing a market entry before they enter Indonesia, so they are aware about the tax treaties and general landscape as to whether what is the withholding tax on exit or dividend tax or all forms of taxes which are applicable. Let's talk about risk. I guess that's the most favorite question of any general counsel or investment committee, risk of the deal. And let's focus on the risk associated with potential delays or surprises. I mean, in my experience, I have not seen a M&A transaction which has gone beyond smoothly and no delays or surprises. So I'll start with Afriyan there. Afriyan, in your experience, what are the standard delays generally investors see, or what are few of the surprises what you have seen investors have gone through, and how as legal counsels we can help them?
Okay, thank you, Pinay. About delays, I think it's not. I think generally the delays comes from many factors. There is from regulatory compliance kind of thing. If it's related, if it's about the sector, is whether there's foreign limitation, like previously we have discussed, kind of thing. So that's number one. Number two, probably is like also from OSS for license for when you require. Then for specific sector like mining or energy, you need to get approval for any change of shareholders. You need to get approval from the Ministry of Energy and Mineral Resources. For financial institution, you need to get approval to obtain approval from the OJK kind of thing. So that is also important. Then also from the KPPU. KPPU is under the antitrust. When you have a deal, this is not only any M&A in Indonesia, even like overseas transaction that involve that the company has an activity in Indonesia or have a business in Indonesia, you need to notify the merger filing notification to the authority, which is the KPPU. This is, I think, the well-known case is about related to when Grab and Uber merged in Singapore. It's not directly have an entity in Indonesia, but its impact to the ride-hailing in Indonesia at that time. So that's why the KPPU issue a new regulation that any overseas transaction is also involve the Indonesian authority. The other thing that needs to also to be seen is on the agreements between the clients. This is not from the authority. This is from the contract or cooperation or contract with other parties. Whether there's a covenant on that one, like say for example like securities kind of thing, any approval that needs to be obtained before the transaction can be happen. That's probably that I can see, Vinay, in general.
Sri, you have done a lot of M&As generally. Any like a post-deal surprise you would have seen that has come up, or any delay that the client did not anticipate at the time of doing a transaction in your timeline, what you had mentioned, 3 to 6 months? Share some of your experience and how you think that could have been avoided.
Okay. So this is a bit interesting because the problem sometimes come up not because of, it's not, when we see from the surface, it's not a huge problem. When you meet with your potential partner, you'll be like, what you do, right? Oh, I'm doing this business, blah, 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 blah. Let's just say, for instance, this is a real case. What the acquirer were expected the company to engage in is actually in retail businesses, because that's what they know. I mean, we're importing, we're trading electronic goods. We're doing retail businesses. But once we do the legal due diligence, apparently they're not a retail company. They are wholesaler, meaning from the get-go, they don't obtain, they don't possess the right, the right licensing, the right permits. And I believe, of course, we always advise the clients, when you want to acquire a company, you need to be in a proper form, right? You need to be able to actually execute your interest, your expectations. Before they do legal due diligence, they'd be like, oh, they can actually do that. They can sell directly. We're like, no. They are a PMA company. Again, I think this is already mentioned by Afriyan in the previous question, that no, even as a PMA company, you cannot do direct distribution. You need local partner. So not only you need to adjust or rectify your business activities and business licensings, you also need to restructuring your what we call business structure. Not only licensing, but partnership from A to Z. So there are just too many homeworks that need to be completed. And even though it looks like a small issue, which can actually be avoided, prevented, if they know exactly what they want to do and they can obtain the proper license from the get-go. So yeah.
Fair enough. So it's more like whether the issue is small or big, they need to talk to the lawyers first.
But I just remember that there's one case also related to employment. For example, if there's any change of control of this M&A transaction, the employee of the company has right to request for compensation, kind of thing. So that is also makes a delay. Usually, the seller will ask the acquirer, then with the seller will then discuss who will bear this payment or compensation to this employee, because although that the employee still continue to be hired by the same company, but under the Indonesian law, if there's any change of control, employee has rights to obtain a compensation.
Yes. So that changes the deal value.
Yeah.
Coming to the tax side of life, now lawyers are even told to include tax indemnities in the agreements, because we believe a lot of these surprises comes post-closing, whether the claim is from the tax authority, employee, or any firm. So in your experience, what are the pitfalls, what you see in post-closing deals related to tax, whether it's a tax authority, employee, any other scenarios, and how you would interact with the legal team, or how you would like to advise your investors? So you want to take that?
So sometimes when there's a deal, so from the tax point of view, if let's say from the tax due diligence that has been conducted, and then there's a material findings, potential tax exposures there. So usually the buyer would like to, of course, with the help of the lawyers, to put that amount in the escrow account.
Okay.
So that fund will be released after there is a clarity that tax finding is no longer a risk for the buyer. And sometimes the seller can agree or cannot agree. So there's a lot of discussion that can delay for the transaction, right? And sometimes I see often the seller say that, okay, just treat it as a discount. So I don't want to be involved anymore. So it will be calculated in the selling price. So that's that kind of discussion happen when the deal. So because the tax, if there is a potential big tax exposure, of course that will influence the cash flow of the company. Right. So in the deal, that is the most crucial things, I think, that need discussion, of course, with the help of the lawyers.
Very important. I'll go a little further on that. So let's say you're talking about a tax exposure, a potential tax exposure. There are two forms. One, which you could figure it out during the due diligence, for which there is no notice, no claim letter, nothing has come. Second would be which, based on your due diligence, you believe that 1 year later, the authorities, there is a potential that authorities may have a claim. I don't know about Indonesia, so a lot of jurisdictions have a time limitation. So in certain jurisdiction, it says the authorities can ask a claim for up to 7 years or 8 years. There is a time limitation. Now, if I'm a client, if I was to ask you that, Aristo, escrow thing does not work because I don't have a claim. Yes, there is a potential. The claim may come for next 7 years. So will I be putting my money for 7 years in an escrow? So if this is a question what comes to you from a client, what would be your view or inputs?
Okay, so in Indonesia, the tax office has a limitation to issue a tax assessment on a company.
Okay.
So there is a 5 years expiration. So let's say for 2025. So after 2030, the tax office could not issue any tax assessment on the company. So when we are doing the tax due diligence, we are going to see whether there is a fiscal year 5 years backward that has not been audited by the tax office. So if it has been audited, then it is good to go. So every year, client has been audited by the tax office. It means that the risk of exposure is very low. But let's say there is we call it an open years that has not been audited by the tax office. That open years, there is a risk for 5 years from that fiscal years that the tax office may come to audit. And if, let's say, they don't come to audit that company, means that it's clear. So after 5 years, the money can be released from the escrow account to the seller.
Understood. So in your summary, for lawyers, if there is a tax indemnity or there is a tax representation and a warranty, for a 5 to 6 year time limit is perfectly acceptable.
Yes.
So it minimizes the risk for the investor.
Yes.
I think I would like to add.
Yes,
If it is a tax audit, then yes, it's 5 years. But again, dispute in Indonesia, you can go from tax audit to tax objection. After tax objection, there will be tax court session.
Yes.
And after tax court session, you can always go to judicial review. Sometimes it takes more than 6 to 7 years to finish everything. But again, if it is open year for audit, yes, it is 5 years enough. But then if it is an ongoing process until judicial review, then maybe you need to consider 6 to 7 years. Yeah.
Interesting. Now, we have discussed about issues what can come. But if I take a step backwards and if I had to advise my client on structurings, so Aristo mentioned about escrow, but generally, if I had to advise my client that this is how you should structure to avoid risk, whether in forms of regulatory approvals or any structures, what would be our advice to the client when it comes to avoiding these kinds of pitfalls or surprises and helping them close the deal in a timely manner? Sri, you want to take this?
Okay. I think if there's one thing that I want investors to know about Indonesia is that everything that we have discussed so far, from the structure, from the approvals, from the tax implications, everything is important and they are very correlating with each other. again, Indonesia is a very procedural country, right? And because of that, orders are very important. They're very critical. Some actions needs to be done before you even sign any agreements. Of course, the structuring, right? The structuring, the term sheet, and so on. Some things needs to be done before the closing. Some things need to be done even after the closing, like KPPU notification, or even post notification of acquisition newspaper announcement, and even some before and after operations. So these are very critical things. So the investors need to map these processes and approvals correctly, so they can avoid any unexpected surprises. Because one wrong step, you might need to redo your businesses, like what I mentioned, right? Wrong business activities, wrong permits. You need to basically redo your business from the from zero, and I think the most implication is that you don't want to attract government attention. That's the last thing that any investor, any business actor needs. And then I think after the approval, I agree with Ibu Alice. We need investors need to think about the exit plan. I'm not saying that you need to exit Indonesia, but as a business actor, of course, you want to have a plan B. And because you need to properly think about your exit plan, whether you want to have a specific kind of rights or authorities when it comes to share transfer, limitations when you want to invite new investors, or even through IPO. Because again, Indonesia is very procedural centric. All share transfer, IPO are strictly regulated. And again, your exit plan will be affecting your tax liabilities and tax requirements. So exit plan will also be very important. I think the third thing, it would be the structure itself, because sometimes the structure will look good on paper, but it cannot be implemented in real life. Especially if we want to talk about one specific matter, it will be about nominees arrangement. A nominees arrangement is not recognized in Indonesia. It's illegal. So you cannot do that. You can probably put it on the paper, but when it comes to implementation, they're illegal. You cannot do that. So I think the investors needs to understand that there are two major documentations that need to prepare. At least they need to understand what articles of association is. And when it comes to business partners, they need to understand what shareholders agreements and what joint venture agreements. Because when it comes to the company's abilities, rights and obligations can probably facilitated through the articles of associations, but the investors' relationship, it should be regulated in the shareholders' agreement, because practically speaking, you cannot put everything in articles of association. It's a public document that you need to submit to the government. So you need to have these two particular documents in place. Again, you might need to appoint correct lawyers and advisors to do that. And I think from the get-go, to avoid any unexpected implications or complications in the future, they need to start to think about legal and tax alignment. Because, we go hand in hand. And I believe, as advisors, we believe that everything needs to be in compliance. So you need to, so they need to understand that everything should be in order, align with what the laws and regulations says, despite probably a different route might offer a efficiency in terms of tax. So if I can summarize this topic, I think a good investors in Indonesia, they can work good if they plan early, if they can manage their expectations in terms of the timeline, they can properly structure their exit plan, and of course, they can think about their tax and legal alignment. Because I think Indonesia, in general, the government and the legal structure, we appreciate patience and procedures, and not shortcuts, obviously.
Now, looking at that, coming to the tax side again, for any deal structure, I have seen it's less legal, more tax, because generally it's there is a saying how the money coming in, what the money is doing, how the money is going out, and all three windows tax comes into the picture. So Indonesia is a big market. When clients are looking at investing, obviously the view should be long term. So whether it's a direct acquisition, indirect acquisition, what treaties, as Alice touched upon the previous time, the withholding, the dividends, what will be your general strategic advisory to clients when they are thinking of entering Indonesia in terms of structuring the transaction?
Okay. So when they want to invest in Indonesia, that can be the investment can come from acquisition or maybe establish a new entity in Indonesia.
Okay.
So if you acquire an existing company, we have discussed previously, but maybe if you want to invest directly, so let's say not direct, I mean you invest through a new establishment in Indonesia, you need to see, number one, are you choosing the correct type of business form? So in Indonesia, there are many business forms, such as you can choose private limited, or you can you only based on a permanent establishment. You only create a permanent establishment in Indonesia,
Right.
or maybe you just create a joint operation based on the agreement with the Indonesian parties. That can be chosen by the investor. So choosing the right type of business form is very important because it's the first step if they want to come to Indonesia. And after that, of course, like we already discussed, I agree with Sri that we have to consider everything from legal perspective, whether there is a negative investment, there is limit the investor to come. And then from the tax, we need to see what is actually the tax cost that will happen after they come, when they are doing the business here, and when they exit. So everything must be calculated in front.
Right.
Because they don't want to come to Indonesia and then suddenly they could not comply with the regulation and there's a huge penalty that will disturb their business in Indonesia. All of them need to be prepared from the start.
Understood. So it's more of engaging with the legal and tax advisors at the time of term sheet itself. That kind of helps structuring the transaction, making a client aware about the pitfalls and possible things that can be done, which fits into the scheme of things in Indonesia, as well as the client's intercompany arrangements. Looking at, I would say, the last thing about practical takeaways. So we have discussed number of issues, and Sri also in the last point you pointed out what things we can see. But Afriyan, if a client approaches the general counsel and says that we are looking to enter Indonesia market, what will be practical tips or things what a general counsel should be aware, or possibly inform their investment committee that these are the key things which are very important and practical when it comes to entering Indonesia? So, and again, the idea would be summarize our key takeaways for our listeners and trying to understand what are the things to be done for entering Indonesia.
I think the first thing is the regulatory. That is important. Like I said previously, that Indonesia has many of regulations, state regulations, regional government regulations. That also makes the company has a lot of license and permit. This is probably the most questions that coming from foreign investor. They said, oh, there are a lot of permits and license that need to get to be obtained for doing business in Indonesia. For specific sector is probably can be double, like energy and mining. That is double of the permits, more permits towards permits than license. That's the number one. That's why I think, like you already mentioned in the beginning, the market entry memo is very important. So you know how the market it is. The second thing is your local partner when you are dealing in Indonesia. Yes, we have a big market. We have a big population. We have 290 people. And it's if you are doing like commercial things, manufacturing, or doing kind of retail activity is very interesting. But then you need to find a good or correct local partner, and you probably needs to do a due diligence also, not just to the company, but you also need to do a due diligence to the local partner that you like to have a partnership, like a joint venture or kind of thing. I think that is the two things that needs to be involved. Other than that, probably a dispute settlement kind of thing. But that's probably when it becomes worse, then you can touch there. But at the beginning, I think we are not going to that portion at this time. But that's
fair
probably
enough. Again, in a lot of M&As, there was once a lawyer who said, if you're forming a JV is like a marriage, and divorce can be very expensive. So you need to select your JV partner very carefully. Alice, if you had to summarize practical takeaways on a tax side of things, what would be your advice for GCs or the financial team generally if they're looking to enter Indonesia?
Like you said, Vinay, forming a GV in Indonesia is like a marriage.
Yes.
Then I need to say that we need to manage the expectation of timeline, because entering business in Indonesia is not as easy as 1 or 2 weeks. You need to work out with the legal, you need to work with the tax structure, and of course there's always tax implication when you're entering the structure in Indonesia. As the one thing to make sure to manage the expectation. And then the second one, you need to see the compliance. Again, not only the compliance of the local partner, but also the company that you want to invest in.
Right.
Because when you see the compliance level of the company, you need to see, well, now we are entering the Cortex era. So you can see everything, every information in the Cortex system.
Right.
So if you're not dealing with it correctly, then you cannot operate the Cortex system. I think that's two notes that I need to mention from tax.
Wonderful.
If I may add,
Please.
Because I've been lawyering for, I think, 15, 16 years now, but I had a privilege to also serve as an in-house counsel for 3 years. So if I may add from the internal, probably the target company, as an in-house counsel, we have additional homework, because we're not only overseeing regulatory, we're not only overseeing permits and licensing, we also need to manage commercial interest of our shareholders, of our boards. And I think continuing to my answer from the previous question, in addition to making sure that all the licenses, all the permits are in place, I think we as an Indonesian council need to change our point of view, that instead of fixing things later, we need to prepare and build a strong foundation. And that is why I mentioned that shareholders agreement, if there are multiple investors involved, are very important. Because in Indonesia, we trust each other so easily. Oh yeah, we have dealt about this 2 days ago. Where's the proof? I've still seen this happen too many times in practice, which can easily be avoided, prevented, if both parties sitting together be frank with each other. This is what I want. This is what you want. And let's put it in writing, sign. And please, always making sure that there is Indonesian version of the agreement. Sometimes it's still unbelievably speaking, it's still there. Some agreements are still in English only, which will be an issue, not only from the get-go, but if there's a dispute in the future.
I fully agree. A lot of times our Indonesian lawyers have reminded of the fact that Bahasa translation is very important when you're signing an enforceable agreement. With that note, thank you to the experts. I hope that the session was insightful and you would have learned something from it. If anything further, any clarifications, inputs, or any further discussion you need to have, please feel free to contact our speakers and they'll be happy to guide you through the intricacies and the landscape of Indonesia. Thank you all for listening to us. Have a good day.